Welcome to Bloomberg Law. I'm Lee Pacquiao. About a week ago, the Federal Trade Commission reached a settlement with Facebook over allegations that the website disseminated sensitive user data to advertisers and software designers without first obtaining the user's consent. This resolution, along with previous settlements with Google and Twitter, appears to signal at least the broad contours of a set of guidelines emerging for online privacy expectations. Joining me now to discuss the settlement and its implications, we're joined by Gary Kibel. He is a partner at the law firm Davis & Gilbert, based here in New York City. Gary, happy to have you here.
Thank you very much, Lee.
So, what happened here? What prompted this investigation?
Well, an investigation by the FTC is sometimes prompted by consumer complaints to the Commission, the FTC's own investigative efforts, or sometimes others in the industry may be complaining about a practice. And an investigation does take some time. So Facebook must have been working with the FTC for a good deal of time on this investigation on a confidential basis. And then once they decide to agree upon the language of a settlement, that settlement becomes public and is open for comment.
Now, as I said before, this settlement is the third major settlement in the technology space, I guess you would call it, that the FTC has entered into. They previously settled with Google and Twitter. Was that investigation and settlement similar to the other two that happened this year?
Well, this Facebook settlement I would categorize in the area of privacy, and the FTC has been very active in the area of privacy, and there's actually been many settlements, almost 20 settlements in the area of privacy. The Google settlement also had dealt with privacy, and Twitter dealt with privacy. There were similarities to the Google settlement in that it dealt with disclosures to consumers about how their information would be used. The Twitter settlement was a somewhat traditional unauthorized access where hackers had gotten access to passwords, administrative passwords on Twitter because of trying to hack that system, and were able to change people's accounts and send unauthorized messages from Twitter accounts.
So let's unpack the Facebook settlement. What's in there?
So there's a number of things. I mean, firstly, the FTC had alleged that Facebook had misrepresented to consumers the way that their information would be used. There was also concerns about material changes that Facebook had made in 2009 to their privacy practices, and that those practices were applied retroactively. There was also a program temporarily called Verified Apps, which had to do with downloaded apps on Facebook, which Facebook would say had been quote-unquote verified. And also there were some allegations about how they complied with the EU-US Safe Harbor framework for transferring personal information from EU consumers. So in the settlement, there's a number of things that Facebook is required to do going forward. The first and most obvious is don't misrepresent to consumers how you will use their data going forward. One of the more interesting things, and this is becoming more of a trend from the FTC, is that if there are material changes in the future to how Facebook is going to use personal information of users, not only do they need to get consumers to opt into that change, but the disclosure needs to be separate and apart from the privacy policy. Now, I'm a lawyer. We spend a lot of time drafting privacy policies and try to make them 100% accurate. The FTC is not saying those policies are no longer important. What they're saying is those policies really need to live outside the document. The concern is that consumers may not read these policies. They don't scroll down to the bottom of the page and click the word privacy. So having these disclosures in a very intuitive manner outside of the privacy so that the privacy policy becomes more of a living document is an important issue.
Now, in your opinion, do these guidelines outlined in the settlement have any meaningful impact on the user's experience?
Well, I think users can expect to see some more information presented to them. The FTC is looking at this from the consumer's perspective. What is the consumer's expectation when they sign up for a service? The expectation is that they are going to assume that the service operates as you would intuitively expect. They don't think the consumer is going to scroll to the bottom of the page and read a lengthy privacy policy or terms and conditions, and that being the only place where the consumer can find out how it works. So if on screen, when a consumer is signing up for a service, an online service indicates that they won't share their information with any third parties, they have to live by that promise and can't really contradict it in legal terms buried elsewhere.
Now, Facebook's business model, at least in part, is predicated on mining its users' data and then selling it to third parties, mostly advertisers and software designers. Does this settlement fundamentally affect Facebook's business plan going forward?
I mean, this is not going to change the business of online data sharing and selling. It's going to change the practices in that business. It won't eliminate that business. Sharing and selling data between marketers and interactive companies is a very big business online, and it's an important business because it helps sustain free websites through effective advertising that are targeted to consumers that might be interested in those ads.
Right.
This is a practice that's existed for decades in the offline world, through couponing and catalogs. So it happens in the online world too. The concern is that consumers need extra disclosures online to really understand what's happening with their data and to give them some control over whether or not it's used.
Right. But if companies need to do more on the front end to ensure that privacy standards are met, doesn't that ultimately affect pricing for advertising placements down the line?
Yeah, I mean, data is a commodity, and when a business launches, they need to think in advance about how they want to use data so they can put policies and procedures and practices in place in advance. It's very hard to completely change a business model and do a 180 midstream. And that's one of the things in the FTC settlement about making retroactive changes, that you would need to have an extra disclosure to consumers about this. So a business can take away from the Facebook settlement that they need to think about all their intended uses of data in advance, and then when a consumer first engages with them, to give them disclosures that clearly explain how data might be used.
How will this affect Facebook's IPO that's, I believe, been slated for spring of 2012?
Well, I mean, this is just my opinion, but I always think it's helpful to resolve any pending investigations by a regulatory authority. The markets don't like uncertainty, and you don't want something hanging over your head which you don't know the outcome will be. So I think this might actually be helpful to take care of it, and then they can move forward doing best practices when it comes to privacy.
These settlements taken in sum with Google, Twitter, and Facebook now all having reached some sort of resolution with the FTC. How do they shape the legislative landscape with respect to privacy expectations? Are we going to see a comprehensive privacy legislation coming out of Congress after this development?
Well, one of the reasons the FTC is very active in this area and that we look very closely at these settlements is because there is no one overarching privacy law in the United States that would address these issues. It could possibly help the industry to give some certainty if there was one standard, and then companies could compare themselves against that standard and try to comply. I think that it's possible that there will be legislation. Privacy is one of those nonpartisan issues that I think everyone can get around. It's certainly a positive thing to protect consumers, protect children online. And many of these issues that we see in the Facebook settlement and in the other settlements are issues that have come up in bills that have been proposed in Congress.
This is a tough question to ask, so I'm going to preface it thus. But if you were to anticipate what Congress would turn out in terms of some sort of privacy legislation, what types of things do you think would be in there? Are they going to go further than the FTC settlements, or are they going to roll back the guidelines that they've put forth?
Well, you're right. It is a tough question. If I had to guess, I think the easy low-lying fruit would be giving consumers proper disclosures, giving consumers control over how their data is used. Then some of the more complex issues are whether we should be in either an opt-in or opt-out model, whether consumers need to opt out of their data being used in certain ways, or whether they need to affirmatively opt in to their data being used in those ways. But I think any legislation will give some guidance there, and then we'll give also the FTC some clear guidance about how to proceed with some enforcement actions.
It's tough to get inside the minds of legislators sometimes,
yes.
But we thank you for the attempt. Gary Kibel from Davis & Gilbert, thanks so much for coming in today.
You're welcome.
If you'd like to learn more about the cases and issues we just discussed, be sure to check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. I'm Lee Pacquiao. Thanks for watching.